Hear ye, hear ye. I have the Chief Justice and Justices of the Supreme Court of the State of Michigan. All persons having business with this honorable court are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States, the State of Michigan, and this honorable court.
Good morning on this unseasonably warm December day. This is the final set of oral arguments for the calendar year, and we welcome each of you, the advocates as well as the visitors. For those advocates who have not been with us before or a very long time, the calendar cases permit you to argue 30 minutes per side, the first 5 minutes of which are brought to you free of our questions, so you have the opportunity to develop, and I encourage you to do so, what the outcome determinative issues are that you believe should persuade the court that your arguments should prevail. We have read the briefs. We don't need to have a recitation of facts, except so far you believe that they are important to understanding the point you're making. The non-calendar cases are 15 minutes per side, with the first 2 minutes question-free. And with that introduction, I call the first case, People versus Tomasik. Is it Tomasik or Tomasik?
Tomasik.
All right, good.
Good morning, Your Honors. Chris Tieber on behalf of Appellant Dennis Tomasik. I will manage my time and try to reserve 3 minutes for rebuttal. As this court is well aware, this case has had an incredible procedural history. In fact, I've been working on this case since I passed the bar exam back in 2007. There's a lot of information here, countless briefs, and multiple issues. So I will, in fact, waive that question-free period right from the beginning here. As the Court of Appeals has noticed in their last opinion, this case boiled down to a straight-up credibility contest. The only properly introduced evidence against Mr. Tomasik was the testimony of the complainant. The 3 issues named in this court's order, granted leave to appeal, are all interrelated, as they all deal with evidence that improperly tipped the scales of that credibility contest against Mr. Tomasik, denying him a fair trial. And obviously I will take questions on all issues, but I'm going to begin with the Musser issue. The introduction of the entire interrogation with no redaction in this case was highly prejudicial against Mr. Tomasik and improper under this court's ruling in People v. Musser. The jury was allowed to hear that the investigating detective in this case say any number of things that would obviously not be able to come through on direct testimony. I'm going to just list a few here. I'm not going to lie about anything. I know my investigation skills are there. I'm very thorough. I investigated the heck out of this case, indicating that prior work was done, and I know that everything is going on here. She alluded to interviewing the family prior to and investigating those aspects, and again repeating that everything they said would be true, and that she repeatedly said that she believed the complainant in this case. Now clearly, this is the type of improper vouching that, again, and the backdrop of a straight-up credibility contest is severely prejudicial against the client and against any defendant, and exactly the type of situation that this court unanimously decided in Musser would not be allowed.
But isn't the difference in Musser that counsel actually objected? So here, counsel didn't object to the introduction. So to find for your client, we'd have to find under plain error?
Plain error, correct.
Okay.
And I believe that in this situation, that it clearly rises to that standard. That it clearly is outcome determinative in this case.
But outcome determinative can't be enough, right? In order to get over prong 4 of our plain error jurisprudence, we have to decide that the error that your client is actually innocent, or that it seriously affected the fairness, integrity, or public reputation of judicial proceedings independent of the defendant's innocence. So can you explain to me how that standard is met here?
Sure. First off, the proofs against him basically, again, come down to only that of the complainant. in
It's
this
a
case.
credibility, closely,
Right, and
the defendant versus the complainant.
right, and there's many instances here of inconsistencies in his testimony.
The jury all heard that.
Right. I guess I'm confused as to what.
No,
Well, our standard is in order to grant relief when there was no objection made,
Right.
we have to determine that your client was actually innocent. So mere outcome determinative doesn't seem to be enough.
that either your client is actually innocent, or something about admitting this unredacted interrogation is so fundamentally unfair that the process itself was tainted. That's
Right,
essentially-
I mean, and that's what our argument here is, that.
Well, there are a lot of errors that don't go to the core of the fairness of the process.
Right, but
It's an evidentiary error, right? And
It is.
It meets arguably all the other of the Kane elements. It's the fourth one you're having problems with, isn't it? So tell me why either we could conclude when the jury did not that your client is actually innocent, or that this is such a core violation that the fundamental fairness of this trial was affected by this.
Right, well, I think the issue is not just looking at it specifically with this issue, but when you combine it with the next issue, which we'll get into, of allowing other improper evidence. Basically, all of this trial came down to evidence that was allowed by the prosecution that should not have come in. And that was the only evidence against his client. So, again.
So you're making a cumulative error?
Yeah, can we aggregate those like that, or why don't you, maybe you could satisfy us before aggregation, like just tell us why the interrogation admitted in full really affected the fundamental fairness and integrity of the proceedings. Just
Right, well, again, as I stated at the beginning, there's no way that this information could have come in had this detective testified at trial.
I think everyone agrees that gets you through the first three prongs. It's just, but convince us that this kind of error was so much different than the other kinds of errors that go on in trials that we excuse, such that it affected the basic fairness and integrity of the proceedings. Why was this one so much worse, I guess?
Again, I think it just has to do with the lack of proofs in this case. I mean,
Okay.
you know, this case, again, it's an almost astonishing lack of proof on top of the fact that this complainant has had serious problems with keeping track of story. Basically, from the start, he has not been able to keep track, of what he's testifying to.
And that's true. I think he testified that he was raped between 200 and 500 times.
Right, depending on what situation.
There's no question, and yeah, I think even his parents testified he was a compulsive liar.
Right.
He said he believed that Batman was real.
Right. Well,
Okay, so the jury heard all of that.
well,
and
the parents testified to two isolated incidents of.
He testified he thought Batman was real.
Right.
He said,
Batman's not real?
in your heart it is.
Right.
That was his
But
answer.
But as far as the parents' testimony about lying, there was two isolated.
I'm not trying to parse all this. I was simply pointing out some of the most flamboyant, bizarre of this boy's testimony to point out that the jury heard it. He said he was raped 2 times, all the way to every time he went over, about 500 times.
Well, actually, I would contest that the jury this wasn't fully brought out by ineffective assistance of trial counsel. I thought, if you reread their record, I honestly believe that this was not fully fleshed out, that there were fleeting references, like you said, to the Batman thing, which was very confusing, and I don't think a jury would have been able to truly get the gist of how far this
Counsel,
kid-
what effect do you think, because it was a law enforcement official, a detective, who was very assertive about her claims in the interview, what effect do you think that had as it pertained to the impact on the jury?
Well, I think that's the critical point. Is I think in this, like I said, in this situation where they're charged with determining credibility between the complainant and Mr. Tomasik having this detective come in under the guise of, of the police shield and basically say that she knows that he's guilty, that she investigated this and she's been able to find all of this investigation to be true. And
do you feel the jury could have possibly looked to her credibility in terms of its findings over that of the complainant?
Look to her credibility.
Do you feel that the way that she conducted the interview, do you feel that the way that she conducted the interview, the way that the jury saw the entire interview, that perhaps that any doubt that the jury had as it pertained to the complainant's credibility could be usurped by the detective's assertions and overall experience as a police officer and detective in the family law division?
Right, exactly, and that's how she led off with saying that she's had years and years of experience doing that. She's a thorough investigator, that she knows what she's doing and knows that everything she accomplished in this case was true. And in a case, again, where there's no other facts for the jury to hang their hat on, I don't see how any jury could come to any other conclusion with that testimony, with those statements being admitted.
Was the impact on the fairness or integrity of the proceedings mitigated at all by the defendant's responses? He had pretty strong and consistent denials. Does that mitigate?
I don't believe it does. I mean, obviously, anytime you go to trial, you're denying that you did this. And if you read the transcript or listen to
but this isn't trial, right? This is a pretrial interrogation. Right.
And if you listen to the DVD, there's two separate parts, basically. The instance where all of this comes in, where she
it's significant because this is the first time he's being informed of the charges, right? Up until this point, he has no idea that this has even been alleged or ongoing, at least from his perspective.
Correct.
And so the interrogation is a way of showing this is his reaction to this news, right?
Right. Now, I think the distinction is when the information that we allege is improper, that came out 3 or 4 minutes and countless, like 8 or 9 pages before she even goes into for his role in this. Basically, she is just going on, and his answers are simply, yes, I hear you. Because at that point, he still has no idea why he's there. In fact, the way it reads to me is that he seems to be thinking he's there for some sort of a witness capacity for something else that happened with Theo or the Jensen family.
I really think to prevail on this, you have to hone in on the standard. Now, in Musser, because it was objected to, the standard, as you articulated, was whether the error was outcome determinative. Here, where there is no objection, it can only be overturned unless we conclude that your client was actually innocent, or there was this fundamental fairness that tainted the process.
Right.
Are you trying to do both, one or the other? Because you really need to hone in.
Right. I mean, I truly believe this is an innocent case, but.
Pardon me?
I truly believe this is an innocent case,
well, then you have to articulate.
But the fairness, I think, is the one.
Let me explain what I'm looking for.
Okay.
My colleagues have done something different. You have to explain to me how I can conclude on this record that your client was actually innocent, or alternatively, why this is so fundamentally erroneous that it affected the fairness. Now, there are a lot of errors that we don't reverse on, that have some impact. And I'm trying to figure out why this error isn't of that class versus the kind that we can reverse on.
Well, again, I just keep going back to the nature of this case, that in a situation where a detective is allowed to basically vouch for a complainant in a straight-up credibility contest, I think that ultimately cuts to the fairness of the trial.
So let me ask you a question. The distinction here, of course, is there was no objection at trial.
Right. And again, we argue that in our fourth issue, that was ineffective assistance.
So let's talk about that, because it can't be that the standard at this stage is the same whether there was an objection or no objection.
Right.
Otherwise, no one would ever object in the trial court because you
Right.
could see whether your strategy works in the trial court, and if it doesn't work, then get it on plain error. So plain error has to be harder than
Right.
preserved error. So let's talk about whether counsel should have objected. So do you think that counsel was ineffective for failing to object? And if so, to what? To the entire video? To portions of the
To
video?
I feel like he was ineffective for not objecting to portions of the video.
Okay.
It was clearly, could have been redacted. The whole first part about her rants about all she knew about this case, he didn't even make answers that were legible. They were like yes and nods, and there weren't even he didn't even have responses. She just kept going. It wasn't until later that it got into a back and forth between them about, what he possibly could have been accused of, or what she's here to do. And this was her build-up prior to that, basically just on a two-page, on the 2 page of the transcript rant about how she knows this complainant is telling the truth, and that that his family is telling the truth.
We got that.
So what you think counsel should have done, I'm just trying to get this straight. So counsel should have objected not to the whole video,
Right.
but to those portions,
Right.
the initial portions that are her vouching
Right.
portions.
The vouching portions, right.
And if she had done that, but left in the other parts that provide context for your client's statement, maybe I'm here for child molestation.
Right.
Is just the vouching part sufficient to determine that there's a reasonable probability that the outcome of the proceeding would have been different otherwise? In other words, to establish prejudice.
Absolutely. I think that's the crux of our argument.
Even if we take out the other portions, so we take out the portions that provide context. So vouching alone is sufficient to cause your client prejudice.
Right.
Is that right?
Right.
Okay, just wanted to know what your
But
position was.
prejudice to the fairness of the entire trial.
No, I think this is
No,
under the
not if
ineffective
we-
assistance
Oh,
theory.
oh, this is
You
under
know,
the
This is
ineffective-
another way to get there.
Okay.
And it's a
Right.
different standard, and maybe a better one for your client. So I think
Right.
Justice
and
Larson was
that's why we ran under both scenarios, depending on what this court.
Because there was a Ginther hearing here, was there not?
There was.
And what was the evidence, what did the trial counsel say about why they chose not to?
It was a very limited hearing. We tried to get this expanded. So this topic.
Was there any testimony from trial counsel about,
There was, but not on this topic.
not on this topic?
Right.
Were
Again,
you restricted from asking?
we were restricted to certain two or three specific points
Which were?
based on Dr. Kielszewski, the failure to introduce his own expert to counter their experts.
Yeah.
And then some testimony from the wife in this case on character witness. That was the two situations that we were, and then obviously,
The order,
The
the Ginther
defense
order was
attorney.
limited to certain issues?
right.
Okay.
And again, at every chance, we asked to get this expanded. Not only for that, but, we had multiple other things that we would like to have brought in, as far as other witnesses or children from the neighborhood that would have vouched for basically everything that Theo says was a lie. Basically, that these kids that were in the neighborhood every day with these kids never saw him at this house, and yet he claimed to be there 5-6 times a week. And we had 5 or 6 affidavits from just the children. We had 5 or 6 more from other families, adults that lived in the neighborhood, that all would have shown that this kid was never around the house. And furthermore, we had work records that showed that he worked long hours, that Mr. Tomasik worked long hours and variable hours, and to make this an incredible accusation that he could have been even available to do the types of acts that are suggested in this case.
Are you laying any heavy weight on the failure of counsel to call a counter expert in light of the?
Well, that actually leads into our second issue, which is Mr. Cottrell's testimony on the CSAAS evidence. Now, as you know, from our briefing, what we're saying is that the scope of this type of testimony has gone way overboard in the trial courts. Since in the 20 years since Peterson has been decided, I think it's basically become almost a free-for-all for getting this type of evidence in. Now, to answer your question specifically, we would say that it should be limited.
Let me just frame it then.
Okay.
If Peterson remains good law, such that this testimony is generally admissible, it might be outside the scope, but if it's within Peterson, don't you concede that the Ginther hearing pretty much blows the ineffective assistance claim out of the water, since the expert that they would have called said the prosecutor's testimony is pretty standard Peterson testimony?
I see your point. What I would differentiate is that if this stuff is going to be allowed, which again,
that's a different question.
We're salvaging.
I'm just
right.
talking now on the merits.
I'm saying hypothetically, let's say that all of the Cottrell testimony should have come in. In that situation, no, I do believe that it would have been beneficial and vital for the defense to call his own witness just to clarify the point, so that it wouldn't have been as one-sided as it was. I mean, basically,
arguably, you have your own expert saying, "Me too."
Well, there's certain facts. I mean, certainly, you know, there is evidence.
Let me just ask the question.
Sure.
As a lawyer, where your expert says, "I basically agree with the other. I have a couple of minor points I could disagree with." Is there any strategic reason why you might not want to bring that second expert in?
Well, you know, with all due respect, I think it's actually the other way around. I think there's a few minor points that he would agree with.
Okay.
And on the more important points that we say, because certainly there are studies on delayed disclosure, and that's some, you know, and that's basically what he said. That yes, certainly there are times, and that has been substantiated by some literature.
What general?
Outside of that, there is no scientific.
What was the problem with Cottrell's testimony that the non-called expert for the defendant, could have corrected or
well, certainly all of the other points. I mean, this expert testified that riding a bike shortly after being anally raped is somehow inconsistent or not inconsistent, however he wanted to say it at that particular time, with sexual abuse. I mean, obviously this is something that cannot be tested. It's almost absurd to think that you could make studies to show that that was the case, that typical kids would go out and ride their bike after being anally raped.
That's a claim we might be able to look at if counsel had objected and asked for a Daubert hearing under 702, and then there's actually probably a lot to look at here, but none of that happened.
And again, that gets back to our fourth issue, which I agree with you. This attorney basically didn't object. He didn't call any of the witnesses. He didn't do any of the things that we did. In fact, he didn't interview any witnesses beforehand.
But as I understood your presentation of this particular issue, I thought you were arguing that this kind of expert testimony can be admitted in some cases, just that it wasn't appropriate in your case. And I guess I'm curious what rule you would propose then for how we're determine when the testimony is admissible and when it's not.
Right, and I think that comes under, and you see it's fully briefed, comes under the trial court's gatekeeping function that I think has been totally, basically done away with just by common practice. I think, and I don't blame just the trial judges, I think the defense attorneys, the prosecutors, it basically has turned into...
But then as a matter of process, I think you agree with me. I mean, if you get another one of these cases and the prosecution wants to introduce one of these experts, it sounds like you're going to, ask for a real Daubert hearing and ask under 702 for the trial court to take a good look at it, and then maybe we'd have something to look at. But here, none of that happened, and we have from you...
And it's our position that it's actually the trial court's obligation before admitting this
Without
evidence,
being,
to have.
even though Peterson is good laws and
I
the
think
trial court has no objection?
I think they can be good law. They can coincide. I mean, I think
Do you
Peterson.
unprompted, the trial judge has to anticipate what the nature of the testimony is going to be and rule on it without a motion? How would I know as a trial judge what the scope of what's the guy's name?
Mr. Cottrell.
Cottrell's testimony was going to be, unless counsel presented that to me.
Right.
I'm
Well,
supposed
there
to be
has to be
omniscient.
some notice of an expert
Well, that's
testimony.
yeah, okay, you've got an expert. Unless the
Right.
parties inform me that the anticipated
Well,
testimony is likely to violate Daubert, how the heck am I supposed to know that? And act on it sua sponte?
Well, I believe that any time that you're going to bring in an expert witness, that it has to be qualified. You have to make sure that there's some reliability.
Well,
Normally,
This Cottrell wasn't voir dire?
he was not.
Okay.
And that's another
Okay.
prong of our ineffective assistance. Basically, and at the Ginther hearing, he said, well, I've dealt with him before, I know how he testifies.
Okay.
You know, he didn't do anything. Again, this trial attorney didn't even interview the witnesses that he called to the stand.
Counsel, if I could, just because I'm concerned about the time, do you mind moving on to if anyone, I don't want to push past, but I do want to get into that critical issue about the newly discovered evidence, and
Okay.
I'd like you to get into that if you could.
Sure. Now, we truly believe that it's reversible error for the trial court not to have granted the new trial after this court released reports that were obviously favorable for the defense and were clearly material to this case. Now, it was remanded basically on the Grissom test, and I think what it essentially boils down to are points 2 and 4, whether the newly discovered evidence is cumulative, which is what the trial court and the Court of Appeals hung their hat on in their decision denying, and that the new evidence makes a different result probable on retrial. Now, the Court of Appeals again argued that this was cumulative evidence, and again, this is what our discussion earlier. There were 2 fleeting times where the mother indicated that Theo had lied about a sexual incident that happened with his cousin, and at first he denied it, and then he admitted to it. And then the father testified that at one point he had lied about some drug use.
There was a fairly extensive cross-examination where the defense counsel took him through the paces of how many different ways his story about what happened with the defendant had changed. From the point of him declaring in one setting that he had been raped twice to almost 500 times, every time he went and visited the house every other day.
Right.
That's a pretty spectacular cross, it seems to me. You don't think a jury hearing that this witness has had multiple, and not only multiple, not little tiny variations, but huge variations in describing what he claims happened between himself and the defendant?
Frankly, I don't believe that came out cogently based on his cross-examination. I think as we laid it out, and I mean, there were many other points that could have been brought up. If you read in the briefing, there's one that I think really stands out where he actually says that I specifically remember. He says that at the pretrial, the complainant, and he goes through this story where it begins with him riding the bike, and then halfway through it totally changes from his at the prelim until the trial testimony. But it starts out with, this is one I distinctly remember. So I think that was one that was completely missed, and that I think was the most critical of the inconsistencies, because again, he prefaced this with this one I'm sure of. Obviously,
and these 2
I
reports
think
that were discovered on remand are not cumulative
because of the nature of them, that they don't just indicate that this kid lied once or twice in a certain circumstance, what almost any kid would lie about. If you got caught with drugs or you got caught doing something you shouldn't do. That's one thing. These are reports that were created by the school counselors and school teachers who have his best interests at heart. These aren't people that.
Now, if you want to have any time for rebuttal.
That's okay. That these people had his interest at heart, and they're doing this to better this child, and the scope that they say he lies, it's to the point where he doesn't even know what the difference is between fact and fiction,
So
and that he revels.
If I understand you correctly, sir, you're indicating that they're not, that the information from the newly discovered evidence is not cumulative because it focuses, in your view, on the habituality of the lying as opposed to isolated and discrete episodes of lying. Is that fair to say?
It shows a way of life, a predetermined a predetermined reaction that he has.
But if you have enough individual episodes of lying, how is that essentially any different from habituality?
Well, I think if if I was a jury member and I hear that a kid lied because he got caught with drugs, I mean, that makes sense in my head. If I'm a jury and I hear that his counselors and teachers say that they can't even tell when he's telling the truth, and he can't tell, and that he lives these lies and actually seems to get excited about these lies and is drawn to these situations where he's blaming adults for his wrongdoing.
You don't think the habituality, though, was sufficiently communicated by the fairly extensive variety of descriptions of what he had been subject to on the part of the victim?
I do not. I think it's a wholly different situation than isolated lies. I think the jury needed to hear this. And again, this is all framed in a situation where all we have is this complainant's testimony and this complainant's word. And all of these three issues all lend evidence that directly cut against Mr. Tomasik's credibility and completely vouched for the complainant's testimony, which totally undermine the confidence in this trial, and we fully think that a new trial is required for justice.
Thank you.
Thank you.
Good morning. I'm Kimberly Manns from the Kent County Prosecutor's Office here today representing the appellee, people of the state of Michigan.
Could you speak up just a little?
Oh, I'm sorry. I usually don't have that problem. First and foremost, before taking questions, I need to clarify or really correct my argument pertaining to issue 2, which is the expert witness testimony of Thomas Cottrell. In People v. Beckley and People v. Peterson, this court, in finding that this type of testimony was admissible under certain circumstances, also found that the then test of Davis-Frye didn't apply to that type of behavioral science testimony when it's not being used as a diagnostic tool. My mistake was then in saying because Davis-Frye doesn't apply, Daubert doesn't apply at all either. That, of course, is not correct. In Daubert, the U.S. Supreme Court noted that in fulfilling its gatekeeping process, the trial court has broad ways of determining whether expert testimony is reliable and relevant to the issues at hand. And that's said again in Kumho-Tyer, in which, of course, Daubert applies to all forms of expert testimony. But the manner in which the trial court fulfills that duty can change depending on the type of expert testimony that we're talking about. The end goal remains the same, that the jury is going to get information that it needs in order to make credibility determinations and determinations of fact, but that the trial court's ensuring that junk science isn't being placed in front of it in the guise of expert testimony. Child sexually abusive accommodation syndrome testimony is not junk science, and it's now admissible in varying degrees in over 41 states. And many of those have very similar limitations on it as this court has in Peterson. Of course, the expert is never allowed to say that the complainant is a victim, is never allowed to talk about the veracity of other witnesses, but in those situations where there's post-offense behavior that would be misconstrued by a jury evidence or testimony pertaining to behavior of child sexual abuse victims is necessary for that jury to have all the knowledge it needs to make those determinations. And when, as in this case, defense counsel is using that post-defense behavior to attack the credibility of a complainant, the expert is then allowed to state whether behaviors are consistent with or not inconsistent with victims of child sexual abuse. An appellant actually concedes several times in the brief and today that in certain circumstances this type of testimony is admissible. So he's not attacking the reliability of this general type of testimony, just he doesn't believe it should be admitted in this case. We disagree about that. But the people then ask that the court take this opportunity to affirm its decision in Peterson to find that even post-Daubert, post-Kowalski, this type of general testimony is reliable, and then in keeping that gatekeeping function and in fulfilling that, the trial court just needs to ensure that the expert being called has the necessary education, training, and experience to provide that relevant information. With that, I will take whatever questions, if you want to talk about Musser first or this issue, whatever you would like to talk about.
Can I just ask about this particular question? The general field of child response to sexual assault, there are apparently a literature on how children respond to these things. But when you have a social worker testifying, can that person testify about his own personal counseling experiences that aren't subject to peer review studies? How does I guess my question goes to the heart of how do I, as the gatekeeper, assess what is reliable versus that which is episodic, idiosyncratic, based on the personal experiences of a therapist, and therefore not subject to reliability? Do you understand my question?
I believe so. I don't think that there is any kind of bright line rule. It's up to the discretion of the trial court. But when you're looking at a syndrome like this, you need to ensure that the expert has the education on that syndrome and the background in order to give that type of testimony. The fact that they also have experiences of their own. In this case, Thomas Cottrell has worked with over 300 families dealing with this, and seeing evidence of that syndrome with his own eyes, I think also is valuable. So I don't think that's something that the trial court should...
Why is it reliable?
Because it's further evidence of the validity of the syndrome itself, of the studies themselves. It demonstrates that the person talking about those situations has indeed witnessed that as well. So you have this type of testimony admitted in a majority of the states, and you want to obviously ensure that the person in front of you is able to...
One bit of testimony that came out. The question is it consistent or inconsistent with this accommodation theory for a child who has been anally raped to leave and ride his bike home? That's a very specific, fact-specific, to this case, question. I bet there are no studies on that.
In which case, the experience of someone who's been counseling families like that and dealing with children who are sexual abuse victims is very important.
So
you're right.
Cottrell had actually counseled a child who had been anally raped and then immediately rode his bike home?
He's counseled children generally in behaviors that aren't inconsistent with. He gives information on how a jury can evaluate the credibility of these behaviors that might otherwise seem contrary to being a victim. Now, that specific instance that you brought up
Pretty significant one in this case,
was
right?
being used by defense counsel as you know, look, he went out and rode his bike. You're not going to ride your bike after this happens. So the question was...
There might be a real physical reason why you wouldn't ride your bike after being anally raped.
And that was part of the question, is that inconsistent with, and explain why. And he was able to explain why that, if I'm remembering correctly, He's able to explain why children victims of this type of sexual abuse are so intent on making everything seem normal that they will sometimes ignore physical pain. And I'm pretty sure the transcript bears me out in that that's what part of his explanation was. And that is more of a general type of explanation on why children might continue with certain behaviors.
Counsel, can I ask you, what is the relevance of evidence such as that by the expert, in this case, Mr. Cottrell, who says on direct examination, for example, that such things as suicide attempts, drug use, self-destructive behaviors are all characteristic of children who've been subject to sexual abuse, and then on direct examination, or cross-examination, says that each of those things is also consistent with children who've not been subject to sexual abuse. What is the logical relevance of such testimony?
Because the fact that Theo was being portrayed and was a very troubled teenager, had gotten into lots of trouble, had lied, was caught stealing, had attempted suicide, those things were being brought out as reasons not to believe his allegation. The prosecutor was then able to ask, okay, well, is this inconsistent with children of sexual abuse? Is this a reason not to believe him, essentially? And on cross, and a very good cross, the defense counsel was able to say, yeah, but you also have kids that have those same problems that aren't sexual abuse victims. So he was able to negate that. The reason why we still need that type of testimony is, if you consider it this way, if you take
It was the expert, it was the prosecutor's expert who initiated almost all of this testimony. It wasn't in response to anything that the defendant said.
It was in response to things that were being brought out by the defense counsel.
Characteristics of the facts in this case.
Yes.
Again, that recurs to the relevance and logical relevance, I guess. The only thing that makes that testimony logically relevant here is if the incidence of the kinds of behaviors, suicide, acting out, is higher among children who are abused than those who are not. And that's the only reason then that if it happens among both sets of children, then it's not diagnostic of anything.
I think one of the important...
Is that not accurate? Isn't that a logical understanding that you have to have? Unless both sets, abused and non-abused children, unless there's a higher incidence of the same behaviors in the one over the other, then there is no logical relevance to presenting that testimony.
Not when the defense counsel is using those circumstances as a reason not to believe a victim, or not to believe the complainant.
So the reliability changes depending on how it's used? The Chief Justice is asking sort of a straightforward science question. He's just asking you a science question.
I think in Peterson, the court recognizes that general characteristics can be testified to.
Peterson was pre-Daubert. We now have you started out by conceding that Daubert actually does require the trial court to play a gatekeeping role. Admittedly,
yes.
In your case, nobody asked for one, so I don't think this is necessarily something you need to win on, so I'm not sure why you started out this way. But why would we reaffirm Peterson without the benefit of a Daubert hearing and to review?
Because this is the type of testimony that is generally accepted across the U.S.
So says you?
But you've just
so
admitted,
sorry,
counsel, you just admitted the expert said it happens to children who've been abused, it happens to children, these behaviors happen to children who aren't. So unless there's testimony indicating why these are more salient characteristics of children who've been abused than those who haven't, that has no logical relevance that I can understand. It is unreliable, therefore, in a pure Daubert sense.
And if I can try to explain my answer a bit better with an example. This type of testimony, when I consider this type of testimony, it's we're talking about circumstances, typically circumstances that would tend to be used by a jury incorrectly. But there's also then other circumstances that will be used by a defense attorney along with those to all point towards, don't believe this kid, he's lying. in this circumstance, if you have like delayed reporting and you have an instance of, suicide or something more common, and they're saying A plus B equals, if this testimony doesn't say A plus B equals he was sexually abused. It says A plus B equals, that doesn't necessarily mean he wasn't. Without that, in light of the argument being made by defense counsel, you're left more with A plus B equals that kid is lying. So it's not skewing it one way or another.
The
It's
facts,
leveling the field.
Counsel, the facts are the facts. This child was a troubled teen.
He was.
Those are the facts.
Yes.
Those go to the child's credibility. Now, it seems to me the only way you get to come in and challenge those credibility the facts is if you can establish, reliably speaking, that these are these behaviors are more highly correlated with abused children than non-abused children.
I don't know I guess I'd like to ask, is that so? The fact that some factor, say drug use or suicidal behavior, is more emblematic of children who've been subject to abuse than it is to children who've not been subject to abuse, how does that help the fact finder determine whether or not the victim in the instant case fits within the former or the latter category, unless there is something that's more specifically definitive, that there's a more precise characteristic that helps you focus upon one category of child versus another category of child?
I think that when you're dealing with this type of testimony, how do I explain this? It's not, again, that it's based on the argument of defense counsel that troubled kid, don't believe him. In response to that, bringing out testimony that troubled kid might be for another reason, and conversely, troubled kid might not be for that reason, again, is working to not skew the testimony one way or the other, so the jury is then focused on the actual testimony of Theo Jensen and not automatically assuming, look at all the trouble this kid's in, he's lying, or not conversely assuming, look at all the trouble this kid is in, he's a victim.
Do you have to win on this argument to prevail?
Pardon?
Do you have to win on this argument to prevail?
The admissibility of Thomas Cottrell's testimony overall, or certain parts of?
I invited the counsel to make their outcome determinative argument initially. You started with this one. You apparently believe this is an outcome determinative argument for you.
Chief Justice, I started with this one because I recognized in my brief I made an argument that I believe is incorrect, so I wanted to correct that.
What is your outcome determinative argument here?
I believe that defendant received a fair trial. Each one of these issues are dealing with, of course, cases from 2012, 2013, and I understand that they apply to a case on direct appeal. This might stretch it a bit when you're talking about a 2007 trial, but it sounded as if when...
He's entitled to Musser, right?
Absolutely, and you started with Musser.
Why is Musser an outcome determinative case for you in your favor?
Because, as noted by this court or as questioned by this court, he's not able to show that this so infected the integrity of his trial that he should have it reversed. And in fact, I think one of the big differences beyond the standard of review, between Musser and the present case is the posture of the interviews that are being talked about. In Musser, you have a defendant who's told up front right away what the allegations are, and then you have detectives who then go on to say, I've been trained, kids don't lie about this, things like that. In this situation, you have the jury...
Do you think there's a real modal difference between the kind of vouching and assertion of omniscience about what happened between Musser and this case?
It changes the relevance, the importance of the context that we're talking about. It's the lead-in up to defendant's suggestion
I know
himself.
what happened between the two of you. That's not what I'm here to find out about. I want to know from you why.
Which began prompting the increased agitation, the increased anger by defendant, and it was ultimately defendant who suggested he was being...
I'm simply saying, it strikes me that the argument that the kind of police interrogation is markedly different from what happened in Musser is, at least for me, a hard argument to understand.
Well, you also have the instance that the detective in this case, when testifying, laid out from the beginning that it was part of her technique not to tell defendants why they were being brought in because she wanted to see their reaction.
But counsel, didn't she indicate that she was with the family law unit? I mean, it's not that hard to put two and two together here, is it?
That she was with the family and talked to them?
Family law unit. She was
the
part of
family law
that specific unit.
Well, and that goes down again to
So
why
how
they
is that
can't-
I guess my question is, how is this like a huge surprise? Like, I mean, wouldn't most people kind of be able to kind of do an analysis of that and kind of put that together?
Actually, most people would have asked very early on why they were being interviewed by police, which was odd in and of itself. But when you're talking about fundamentally affecting the fairness of a trial, and you have a defense counsel who uses that interview, wants that interview in so that he can argue, what do you mean? She, in closing, said, oh, she makes a big deal about he's the first one that brought up child molestation. Where did that come up? I'll tell you where that came up, back on page such and such. He points to this lead up, and including the mention of family unit service, and including that it was something she knew happened between he and young Theo.
That goes to what consequence, not whether this is a Musser-type problem, right? You want to fight about
Whether
this
it's
is
a Musser-type
problem
no.
or what the consequence
I understand
of the
that.
error is?
I understand that.
You concede it's a Musser error. Plain error after Musser.
Plain error when?
Are you contesting plain error or not?
I think there's an argument to be made in this case, better than Musser, that all those statements were properly admitted for context, but I understand and recognize since Musser, that would probably be a losing
Can I
argument.
make the argument that the error that occurred here is arguably more severe than what took place in Musser? In Musser, this court was trying to assess how we segregate prejudicial evidence from relevant evidence. In the instant case, my question to you is, what is the relevant evidence? Was there anything in this exchange, anything that occurred at the interrogation that was relevant? Anything at all?
The fact that throughout that entire
What was relevant?
interview, we never accused him of child molestation. He was the person that brought that
The
up.
questions certainly were suggestive of the fact that that was what he was being suspected of.
Which is how-
Why would this young child be repeatedly going over to your house? I mean, yes, it could have been a matter of arson that was being investigated, but I think it's a pretty good guess on the part of the defendant that it wasn't arson, it wasn't homicide, it wasn't counterfeiting. It was quite likely what in fact was the subject of the investigation here, criminal sexual behavior.
Which is what defense counsel pointed out in his closing and how he used that entire interview in
but that's the
closing.
whole point. Why was this relevant other than to get him to acknowledge what was probably obvious from the beginning? He was a suspect of child molestation. That's the gotcha here, right?
It is.
Otherwise, you wouldn't have put it on.
But to go right to that and not consider other possibilities, go right to something that extreme and not consider other possibilities such as...
Are you credibly arguing that somebody in this defendant's situation wouldn't put two and two together without prompting? Really?
And then we come back to if that's not a credible argument, you can't show that this fundamentally affected the integrity of the proceedings.
You might want
because
to spend some time on that.
because the defense counsel used this to show that.
So the
Yes,
only
but I'm sorry. Counsel was put in between a rock and a hard place, right? Since you say the relevance to the prosecution is this gotcha moment when the defendant says, oh, I must be here for child molestation. If counsel doesn't let at least portions of that video come in to provide some context, then the defendant's going to look super guilty, because if we redact all the things, then all we're going to have is the detective saying, "Why are you here?"
Exactly.
And the defendant saying, "Child molestation," without all that lead-up context. So I'm wondering, what would a reasonably competent defense counsel have done in this position?
Exactly what this defense counsel did, is use it.
Oh, but not oppose the admission at all, in its entirety?
No. Oppose the admission of the interview in its entirety? No. There would be, these are party admissions by a defendant.
But barely relevant, if you believe the Chief
Still
Justice.
have to be relevant. They still have to be relevant.
Yeah.
Right. And when you have a defense counsel or a defendant coming up with the suggestion himself of child molestation, that is relevant. And when you have a defendant being brought in and not asking the question, why am I here, an odd occurrence, also relevant.
I didn't say that an admission that is contrary to parties' interest isn't always relevant, but this context is a really interesting context.
I would also note that part of what the defense counsel then argued as well is to point at that interview and say, look at what she put him through, and at no point during that interview does he ever admit that he did anything wrong.
Let me see if I understand your argument. A motion to exclude the entirety would have failed because there is a arguable party admission that he was conscious of guilt in acknowledging why he was there unbidden, at least not explicitly told why he was there. That being the case, strategically, it made more sense for the defense counsel to let the whole thing in to provide basis for an effective cross-examination of the interrogator.
Yes, and to make the argument that he made, that look at what she did, look at what she put him through. He never admitted throughout that whole thing, and they try to claim that he suggested child molestation and it came out of nowhere, but here are the places in that interview where it was brought up.
Well, the interrogator said that she works on pretty sensitive cases.
She did.
She knew what happened between him and the complainant, who was a young boy, when the complainant was younger and was spending a lot of time at defendant's house, and that the complainant had no reason to make up a conjured story. And then to respond, you mean child molestation or something? You don't think 99 of 100 people would have come up with a similar response?
Only the conscious.
Pardon?
Only those of us who would be conscious.
I don't think the way the defense counsel handled this case and the way he used this interview that the Musser plain error standard is fulfilled to find that it so fundamentally affected the proceedings that a new trial is necessary on that issue.
Counsel, let me go back to just what I think Justice Larson was asking about the difficult position counsel was in. Let me propose another way a super effective trial lawyer might have handled it. What if I said, you know what, Your Honor, I don't think any of this interrogation can be admitted. I know there's allegedly a party admission, although maybe it's not. Maybe it's just a guessing. Maybe it's not an admission at all. It's guesswork in response to a question. But the only way to admit it is and get rid of all the stuff that everyone would agree is not admissible, the vouching and the other improper lead-up, is just to admit the part that, like Justice Larson said, causes more problems than not. So why do I have to choose between two unfair choices? I think, Your Honor, you have to exclude all of it. Why shouldn't counsel have done that?
Because, well...
Because it's unfairly prejudicial, for example.
Because what?
It's
unfairly prejudicial. It does not meet the 403. If you redact it properly, it does not meet 403. Why shouldn't counsel have made that argument?
Again, when you're looking, if you're talking about, say, an ineffective assistance of counsel claim as to this issue, which is one of the claims that they make, you need to consider this case in 2007 and the admission of a defendant's interview, along with the context of the detectives doing the interviewing, was par for the course in 2007.
It might have been par for the course, but it wasn't lawful. I mean, Musser didn't make a new rule. It just, applied existing law
and I understand
to,
that.
The facts of that particular case. And I agree that it sounds like there was a widespread practice that maybe got reevaluated after Musser.
Yes.
But that doesn't mean it was a widespread lawful practice. And so I'm talking a really good lawyer, a really effective lawyer.
Like one
comes
you'd like
into
to
play.
have.
Like the
Like
one you want.
Musser's
if it was-
lawyer, who argued Musser before Musser.
Yeah, Musser's
Right.
lawyer. If this guy had Musser's lawyer,
So now what is the question?
why isn't why isn't the lawyer's failure to try and do something about the admission of this interrogation a problem for you?
Because you evaluate his decision in light of a reasonable attorney at that time, and it would not have been unreasonable for an attorney to handle it in this way at that time. The defendant.
So I get that, and this is what bothers me. So if we're gonna, and maybe you can just help me think about how the law should work here. So if we're gonna say we're gonna evaluate counsel in light of what a reasonably prudent attorney would have done in 2007
Right.
before Musser, then we say counsel was effective, but then we also, effective because counsel didn't object, but then we also say, I mean, the Supreme Court of the United States clearly tells us you get the benefit of these rules
Right.
on direct appeal, but we're going to say you can't have the benefit of the rule because you didn't object. So you're kind of damned if you do and you're damned if you don't, or darned if you do and darned if you don't. And
Thank you, Ann.
sorry. So I don't know how to think about that, and I just would like some help.
It depends on what issue you're dealing with. If your issue that you're dealing with is ineffective assistance of counsel, I believe the Supreme Court, and I wish I had the case name with me right now, also said that you are to evaluate an attorney's performance in light of the law at the time of the trial.
Does that, if that's the case, does that have some bearing on how we should consider it under the alternate claims of error here? That if it wasn't ineffective and it still was a powerful problem in this trial, in a closely, I mean, this is just the defendant's denial versus the complainant's serial allegations of sexual abuse. In those situations, there are a lot of things that can tip one way or the other in terms of trying to assess the credibility of the accusations against the denial.
And I think one of the things that in an appellate case you lose in the transcripts is, and why we have the deference to the jury, is how a particular witness presents on the stand. And by all intensive purposes, Theo Jensen presented very well. He was very credible, despite the fact that he was a troubled teen, had stole, had lied, all of which came out in front of the
Or
jury.
at least been very inconsistent about what had happened at the hands of the defendant.
Correct.
Well, how did he explain the difference between 200 and 500 assaults?
That went back and forth in his testimony, and I know that at one point it was brought out that, it happened, every time he went over there, almost every time, and he clarified that later when he was talking about, well, of course, no, it didn't happen every time I went over there. The man worked, he had a job, he wasn't always there. You're talking about a 17-year-old talking about instances that happened to him when he was between the ages of 6 and 8. It was brought out in front of the jury, and the jury believed his testimony.
But do you feel that would have been compounded? I mean, we didn't even get into the third item or the third issue, which is the newly discovered evidence. I mean, based on your comment, do you think that would have been accentuated had the attorney been able to bring in those counseling files and those education files and those school files that really kind of compound exactly what you just said?
Justice Bernstein, no one throughout the trial court, Court of Appeals, or even in the brief to this court has explained how those records would actually be admissible at trial. They're hearsay records. At most, they might have given them a chance to bring in character witnesses, those two individuals, which they could have done and put that before the court during the motion for new trial, and that wasn't done. So we don't know how those witnesses would have testified, how effectively they would have been cross-examined, and in short, they were talking about Theo several years before he ever made the disclosure. So I don't think that issue is.
But that educational expert, had they been aware of that, you don't feel that newly discovered evidence could have been impactful if that doctor had been able to testify?
I don't believe that they've made their burden in a motion for new trial on newly impeachment testimony, no.
Even though, I understand the argument that it was cumulative, and I believe reasonable arguments can be made on both sides in that regard, but Musser counseled very close scrutiny in cases involving, first, he said, she said type credibility contests, and secondly, cases involving the testimony of children. Mm-hmm. Why shouldn't those tilt what is, a reasonable argument that can go either way in favor of the defendant here? This was specifically counseled by Musser.
Counseled by, we were talking about the Musser issue?
Musser specifically counseled close scrutiny in the two classes of cases I've just described. He said, she said, one-on-one credibility contests, and also cases involving the testimony of children.
Because in the end, much of what opposing counsel has argued goes against Theo's credibility was presented to the jury and was considered by the jury in varying levels. While a defendant is entitled to a fair trial, he's not entitled to a perfect trial. He's not even entitled to the exact trial that an appellate counsel would like him to have. So many of those...
But opposing counsel is saying it's one thing to hear testimony about discrete episodes of false statements, but it's another thing to have presented to the jury the argument that he lacks the ability to tell the difference between truth and fiction, and that he was typically in the game of blaming adults to get out of trouble.
I would argue that the fact and fiction was already presented to the jury by the defense counsel when he questioned him whether he believed in Batman or not, and he said, yes, to me he's real. And he used that argument in closing. So that problem between fact and fiction... But to me,
he's real is more of a narrative. It's kind of like, maybe that's just his ideological belief, like, to me he's real. There's a difference between the other issues that we're talking about, which show a consistent pattern of behavior in terms of accusations, in terms of the idea of truth-telling, in terms of overall veracity. And in a case where basically you have, I don't really see any physical evidence with the exception of the doctor's report,
Correct.
Which isn't even, I think is hard to even argue here. The whole case comes down to veracity. I mean, other than that issue that the doctor brought forth, that ultimately could have been caused by a number of different things, the only thing here is veracity from 9 years ago. And I guess the question I have is, when the whole thing comes down to veracity, don't these issues become more relevant?
I would say at the appellate stage, when you're getting those reports and you need to show that this is material to this case, you need to do more than to keep pointing to reports that would not be admissible at trial. You need to actually put forth those witnesses and see how they would actually testify and see how they'd be cross-examined. That burden was not met at the motion for new trial.
Thank you.
So thank you.
It appears that there are two adherents to Batman in the Hall of Justice. Thank you. The case is submitted.
And this is the Hall of Justice.
It is. Thank you very much. Jasperson versus